should European policy favour European clouds? Now, this is not actually a new topic. Indeed, in my first book, which has been out of print almost continuously since 1985, I talked about this, and I found some quite early quotes where people were expressing concern. So this is from Canada, quote, "As a sovereign state, Canada feels some national embarrassment and resentment over increasing quantities of often sensitive data about Canadians being stored in a foreign country." Now, no guess, that was obviously the United States of America. And that's a 1972 report, Privacy in Computers. Moving across to Europe, this has been an issue for a long time here too. Slightly spicier language in this one. We do not really trust the data acts in other countries, or we feel there are none at all. So we feel unprotected in those countries with our data, walking down Fifth Avenue in our underwear. Now, I mean, who would say something like that? Well, it was actually a minister in the Swedish government. This was in the late 1970s. But that's just to give you a flavour of how long this has been a controversial issue. And within the Cloud Legal Project and our collaboration with computer scientists in Cambridge in the Microsoft Cloud Computing Research Centre, about 10 years ago, Ian and I did some work looking at whether a cloud for Europe was even possible from a technical point of view, never mind from a regulatory and commercial point of view. And without going into a lot of detail, you can find our papers again. Was privacy the real driver? Well, we will answer that question in a few minutes. And the policy, legal and regulatory implications of a Europe-only cloud includes some more stuff on the technical challenges of actually building a ring-fenced cloud for Europe. Now, sovereignty has never really gone out of fashion, of course. It's a very old legal concept that people have fought many wars over in the last few thousand years. But it's a hot topic again today for various reasons. Geopolitics is definitely back. Those people who predicted the end of history, like Francis Fukuyama, 1992, thought we'd have this global government, everybody will get on really well. Well, it hasn't happened yet, and global risk awareness is definitely growing, and these are just a few examples of, in the technology-related area of supply chain dependencies, which are becoming highly contentious. And we saw in COVID-19, obviously, all kinds of shortages, including PPE and things, and right now in Ukraine, there are issues to do with European security and global energy supplies, Panama and Suez canals, problems there, including supply chains for tech products, tensions between the US and China, which could get, could change, let's say, depending on what happens in their election later this year. And of course, Taiwan, which, a bit late to the game, many people realized in the last 10 years, absolutely critical for the world technology supply chain. If you want a book on that, highly recommend this one. Chip War by Chris Miller. Now, what about European digital sovereignty as it is conceived these days? Well, here's a quote from Charles Michel, President of the European Council. "Digital sovereignty is central to European strategic autonomy." Now, what is European digital sovereignty? Well, if you unpack it a little bit, you find that people talk about ensuring reliable supply of critical materials. So that goes back to the previous comment about global supply chain issues, building European capacity in critical technologies. And there's no time to go into detail here, but here are a few examples. European Chips Act to promote semiconductor manufacturing in Europe came into force last September. European Critical Raw Materials Act came into force very recently in May 2024. In terms of telecoms, this could be a whole discussion. I know Ian has strong views on this too. The EU, like the US, has imposed quite draconian restrictions on use of Huawei equipment. And if you want a good article on how that's gone, have a look at the Economist extensive briefing paper from the 13th of June, just last month, where they say, as not entirely unexpected, it's been counterproductive and it's been actually jolly good for Huawei, but watch that space. And then moving to cloud services, what would European cloud sovereignty be, even in conceptual terms? Well, we have a statement here from Thierry Breton, European Commissioner for the Internal Market, who has said it's becoming imperative to have autonomous European clouds that guarantee our companies that their industrial data will not be subject to any third country law and will be protected against external cyber interference. Now, that's quite ambitious, and Ian will unpack some of the implications of that from a legal point of view in a few minutes. But I want to look from a market perspective at how this strategy for a European cloud is going so far. Well, let's look at the world first, actually. So if you look at the cloud provider market share globally, this is for infrastructure as a service, platform as a service, and hosted private client services. If you want to know what that means, do our Coursera course or buy the book. Right, end of that. But what you see is the big three: Amazon with Amazon Web Services, Microsoft with Azure, and Google with Google Cloud Platform, sometimes referred to as GCP. And then you get the rest of the world. And indeed, the next biggest is Alibaba, which is the largest Chinese cloud provider. It looks pretty small on this chart. It's actually a very big company, but it's constrained in terms of expansion outside China at the moment. So turning to Europe then, and I use Europe in the geographical sense, not just the EU. It turns out these big three hyperscalers, AWS, Microsoft, and Google, are also the top providers in Europe. So if you look at the top three slots there, you see number one, Amazon, number two, Microsoft, number three, Google, with one exception, which is OVH in France, which scrapes into third place. But actually, OVH is a fairly small company, and it doesn't really have any substantial presence outside France. And then you look at where are these European companies? Well, it turns out, apart from OVH, they're all telcos who had a sort of head start here because they already had networks, they already had data centers. But I'd be amazed if any of them can break into the top three across Europe as a whole. So what about market share for European companies? Well, during this period where the size of the market cloud service in Europe went from 2 billion euros to 10 billion euros, the market share for European cloud providers fell from 25% to 15%. So I'd say, Monsieur Breton, it's not looking too good so far, but don't give up yet. Okay, now what would make a cloud European? And Ian and I have discussed this extensively with our colleague Dave Michaels, who is the lead author on the paper we're talking about today. And we concluded we could distill it down to three key elements. A European cloud, well, it could mean cloud for Europe, services provided to Europe. It could mean cloud in Europe, so infrastructure facilities that are physically located in Europe, or it could mean cloud by Europe, cloud provided by European companies. And I'll just very briefly explain what we mean by that before I hand over to Ian. So cloud for Europe, we think means providers of services, cloud providers that are active in the EU market must ensure that their services comply with relevant EU laws. No surprises there. That's true for anybody who wants to sell in to the EU market. And obvious regulatory compliance obligations include GDPR and the NIS directive. So basically, this is already here. Cloud in Europe is a step further. This is more to do with data location, sometimes called data residency. And the idea is that you would have European citizen or customer data stored on servers at data centers physically in Europe. And if you look at the global infrastructure, I'm not going to show you all the maps. There's some interesting maps on the web, but this is just taking Amazon Web Services. You'll see they have servers, data centers all over the world. These are very big hyperscaler data centers. When you drill down to Europe, you can see they have a lot of points of presence and data centers in Europe. And beyond that, we have Microsoft, for example, making a commitment 3 years ago to store and process EU data in the EU. Now, in terms of drivers for data localization, this is just a simplification again, but some might be technical. So in technological terms, if you want to deliver extremely high capacity, high bandwidth data at the edge, then you would build edge networks and you would probably want to have data centers physically in Europe. And that might be for various reasons like streaming, high definition video, or maybe you have real-time trading in a stock exchange environment. Economic arguments might be if you are paying transit costs to telcos, other network providers, a lot of these private networks these days, then you might reduce your costs by being physically in Europe. And in terms of regulatory issues, compliance obviously with GDPR, data transfer rules, and other rules that restrict your activities in terms of moving from the EU to the rest of the world. Now, cloud in Europe is widely available, but it's important to distinguish content data from metadata, and you'll hear more about that from me in a moment. So, for example, if you, and even Microsoft has accepted this in its announcement about its EU cloud, there are some things you just can't keep in Europe. So if you want to have a global Active Directory system where people can do single sign-on authentication anywhere on the planet, if you want to do real-time global threat monitoring for cybersecurity purposes, then actually just restricting that to Europe doesn't make sense. So, cloud by Europe. This is the third one. Is it cloud for Europe? Is it cloud in Europe? Or is it cloud by Europe? Now, what we mean here is that services offered by European cloud providers basically shouldn't be subsidiaries or controlled by American companies. So this is about nationality, I suppose, rather than residence or directing services. And the main European cloud sovereignty concerns can be broken down into these categories: legal sovereignty, data sovereignty, and strategic autonomy. And at this point, I'm going to hand over to Ian.
So if we're talking about elements of sovereignty, we need to think about the different types of sovereignty. And the most obvious one is legal sovereignty. As lawyers, we understand that there are different types of legal sovereignty, from the prescription jurisdiction, your right to legislate, enforcement jurisdiction, and obviously judicial or adjudicatory sovereignty. And it's about a state having exclusive control. And of course, within an electronic environment, that's extremely difficult to maintain that notion of traditional exclusive control, because we have the type of example that I've provided here. And many of you will be familiar with the US Microsoft case, which really tried these particular issues, because US government asked a US provider to get access to data, some of which is held in the US, following on from what Christopher said, simply because in order to subscribe to services, Microsoft maintain a global directory to operate that. But in terms of the content data was sitting on a server in Dublin. And therefore, the question before the courts, various courts, was whether US law had extraterritorial jurisdiction, whether essentially US law enforcement had long arm reach into the Dublin data centre. And much to the concern of the US government, and to be honest, much to the surprise of the Microsoft, the Court of Appeal agreed with Microsoft. And so we ended up having a Supreme Court hearing, which did not complete because essentially the Congress passed the US Cloud Act, which rendered the whole issue moot. But it does have this sovereignty element. To what extent can you, I mean, if US law enforcement turned up in Paris and tried to enter a data room, that would clearly be a breach of French sovereignty. So why isn't it a breach of French sovereignty if US law enforcement reach into a Paris server virtually or electronically through their access rights? And clearly that part of that question is, do we even know that the data is sitting in France? As well as the Microsoft case that most of you are familiar with, there was a number of other decisions which actually eventually helped the case come before the Supreme Court, where Google tried to argue the same issue, that they couldn't provide access to data held abroad because data held abroad was under the sovereignty of other nations. But what the court said in that particular case was, Google, do you know where the data is? And Google had to admit they didn't know where the data was because of the dynamic nature of the processing within the GCP. It could be anywhere at any time according to the dynamics of the system. And therefore, the US court said, well, in this case, if you can't tell us where the data is, we'll hold that it is present in the United States. So it's about trying to determine, where does the conduct take place? Does it take place where US law enforcement make demands of a US cloud provider? Or does it take place where the data is actually residing? Or more probably, it takes place in both places. Data sovereignty, however, is a slightly different notion. And the notion as put forward by European policymakers is much more about control over European data. And of course, this is where data protection law comes into play. It's a separate notion from traditional notions of legal sovereignty. And it's about trying to assert that European law reflects European culture, and European culture gives preeminence, or seemingly, to the protection of privacy and data protection. And therefore, if we have rules in Europe that prevent or control the disclosure of European data to foreign countries, then those rules should be respected. So it's focusing not on the territory where the data is, but it's focusing on the data, both the commercial data of European companies, the Data Act being the most important legal framework governing non-personal data, and of course the GDPR. And part of this is, well, to what extent can US law enforcement access data in accordance with European law? And that is a question, of course, of GDPR. That's a question of, do you have a lawful basis for the processing? It's about whether you can comply with Chapter 5 of the GDPR or whether you can comply with the obligations under the Data Act. Because the obligations under the Data Act, which are yet to come into force, provide an almost narrower set of conditions upon which a transfer can take place, primarily pointing to the need for some sort of mutual legal assistance treaty between the US and the European member state, or some a more complicated process trying to address that particular conflict of law. So we've got compliance with a whole series of different rules in order to achieve data sovereignty. The third concern we have is what we refer to as strategic autonomy. Now, again, if you remember or those of you that did law, if you remember your international law, legal sovereignty, all countries are equal. That's the whole point behind that notion of exclusive control. The notion of strategic autonomy, though, is much more reflective of the de facto distribution of power that exists in the world, as a result largely of not only technological developments, but of course also trade liberalization that has occurred over the past 20, 30, 40 years. And what we have concerns with here is, of course, the dependency upon US hyperscalers is what gives rise to the concern for the ability of Europe to continue to operate in the event of some sort of dispute or some sort of disruption to international trade. And of course, US cloud providers have for long given the US a strategic advantage. That's what the Snowden revelations told us. The Snowden revelations told us that the US was getting a hold of all sorts of data simply because of the US service providers, not just the hyperscalers, a much broader category of companies, were willing and able to hand over data, with, of course, a little help from their friends, the UK. So US, if we think of legal sovereignty as European digital sovereignty as the goal, then strategic autonomy, achieving a strategic autonomy, is the means. And that's really what we see as underpinning European policy in this area. It's about industrial policy. It's about strategic autonomy, cloaked within this idea of data sovereignty. Would it really actually provide a solution? I mean, that's always what policymakers should be challenged on. Does the fact that we have European providers, does that immune them from US jurisdiction? Well, the answer is, of course, it depends. It depends if that European provider has no active business in the US market. Because if it has active business in the US market, then it will be subject to US jurisdiction. So, do we want our our European providers to ignore the US market in order to assure European policy and strategic autonomy? Well, the answer is, sure, that would be great. We'll have a whole series of digital dwarfs residing in Europe who are immune from US jurisdiction, but certainly will not be able to achieve some of the scale, some of the services, some of the efficiencies that the US hyperscalers are able to offer. Part of the approach, of course, of European policy is to say, well, let's go, if we can't achieve US or the size of the hyperscalers, let's go for this notion of federated cloud. We have Gaia X, we have the European Cloud Alliance, various attempts to say, well, it's not how big it is, it's how your ability to move between different cloud providers, multi-sourcing. Even though all the evidence in the market shows that companies don't want to multi-source their cloud, what they want to do is perhaps have hybrid cloud between in-house and public or some other cloud service. But what Europe is trying to push is this notion of the federated cloud. Now, the federated cloud depends on service providers having in place the capabilities to allow their customers to move between or operate between a range of different providers. And again, what we see is the Data Act borrowing some of the language of European telecommunications law in terms of number portability, borrowing the data portability that exists under the GDPR, and adding to that this notion of interoperability. And the hope is that through making regulatory demands for data and application portability, for imposing requirements for interoperability, we will somehow achieve a federated cloud that can, to a greater or lesser extent, compete with the US hyperscalers and ensure European sovereignty. The question is, do we want it? Not you and I, but do European companies want that? Because this is not the first time that this call has come out. Microsoft set up a cloud service with Deutsche Telekom, which didn't survive because it was found that the cost of this sovereign cloud was 20 to 30% more than the use of Microsoft's standard public cloud software offering. And of course, cost in our current industrial environment is really important, and therefore that was abandoned. But we still have, because of this European policy, a great desire to try and achieve this. And we've seen a whole series of initiatives in France, in Germany, trying to build this sovereign cloud solution. The question simply becomes, well, these sovereign cloud solutions recognize and acknowledge that nobody can achieve the functionality and the costs and the efficiencies of the US hyperscalers. All we can do is put a superstructure on top of it that addresses those concerns. But of course, we're not the only jurisdiction that has digital sovereignty concerns. Some of you may have seen in February, not only did the European Commission publish its white paper on the future of the digital economy, but also the United States, President Biden issued an executive order specifically addressing the US concern about unfriendly countries getting access to bulk sensitive personal data from US citizens, and how that was going to act as a competitive disadvantage. So as an author of a book on telecoms law, I've waited years for anything on submarine cables, and in February this year, both the European Commission and the US government came out saying submarine cables are now on the public agenda. So you'll get my book on telecoms law when it comes out in the near future. Anyway, what should we be asking for? Should we actually be, why is there such a strong focus on data localization? Is it to facilitate enforcement of laws, which of course is a perfectly reasonable thing to do, and the whole representative actors is part of that enforcement jurisdiction? Is it about restricting foreign surveillance? We think not really, because as we know, foreign surveillance doesn't necessarily need to occur on US networks. It occurs on any network that can be hacked into. Or is it simply about promoting European service providers, which seems the most obvious thing? This focus on physical location seems completely wrong from a data sovereignty perspective. Finally, I just wanted to mention the Estonian virtual embassy experiment. This was in response to concerns about a foreign power, beginning with R, ending in A, taking action against Estonia in 2014. And the whole virtual embassy experiment was, in fact, the reverse of European sovereignty or concerns about digital sovereignty. What the Estonia, and now we have seen with Ukraine the same situation, is actually by having your data in the cloud, residing on servers in another jurisdiction, you actually give your country strategic resilience that you can't achieve by making sure it all is located within your domestic jurisdiction.